States of America, the state of Tennessee, and this honorable court.
Thank you, Mr. Hivner. And on behalf of Judge Bennett, Judge Golden, we want to thank you, Mr. Feeney and Mr. Smith, for participating in this oral argument via Zoom, which your argument will be live streamed today and will be available on the AOC website for future reference if you or other members of the public need to see it. We will conduct the argument in the same fashion as we would if all of us were in the courtroom together. Each side gets 15 minutes, and Mr. Smith has reserved up to 5 minutes for rebuttal, and Mr. Hivner has already programmed that. Unless there are some announcements, I will ask Mr. Hivner to call the case.
Progressive Specialty Insurance Company versus Ji Yun Kim et al.
Mr. Smith.
May it please the court, I'm David Randolph Smith, counsel for the appellant. I actually reserved 3 minutes for rebuttal time, Your Honor. So, if I
Very good.
This is an appeal from a summary judgment, declaratory judgment in an insurance coverage contract dispute that arises from an Alabama commercial automobile policy. We respectfully submit that the trial court erred in granting summary judgment to Progressive and also erred in failing to render judgment to the plaintiff. We believe this is a question of law, that the interpretation of an insurance contract is a question of law, that it is governed by contract law. And as you may have seen in the briefs, there's a dispute about what is the test. Do we look to workers' compensation law? Do we look to respondeat superior law? We believe in the first instance, you should look to Alabama insurance contract law. And the leading case on that, there are really 4 cases that I think govern this appeal. But the Twin City fire insurance case clearly states that an insurance company that drafts a contract and fails to define terms, that should be construed against the insured in favor of coverage. And if there is a failure to define the terms, that should be considered an ambiguous if it's capable of more than one meaning. And that should be strictly construed. So I think that's the first Alabama law principle that the trial court did not apply. Basically, the trial court applied tort law. There really are 2 contract provisions that we say provide coverage in this case. The commercial auto policy was issued to Sanchez Construction, an Alabama construction company that was coming up to Tennessee to build the Hankook tire plant and do concrete work. They paid an additional $219 for what was known as the Any Auto endorsement. And it covered any auto while used in your business if you are a sole proprietor. Sanchez Construction was a sole proprietor, so there was coverage for any auto while used in your business. Unfortunately, the insurance contract did not define while used in your business. So that's what triggers the insurance contract interpretation principle of construing it against the insured. The other contract coverage provision was the temporary substitute auto coverage. There was also coverage for any auto you do not own, used with your permission of its owner as a temporary substitute for an insured auto that has been withdrawn from normal use due to breakdown or repair. The driver who hit my client, Mr. Kim, Cupido Ernesto Hernandez, he was a foreman who had been provided a company car, a Silverado car, to drive up from Alabama to transport workers from company provided housing with gas provided for both the Silverado. And then when that crashed, he used his own personal vehicle. So I'd like to just go over the pertinent facts. My client, Mr. Kim.
You're saying the personal vehicle was a temporary substitute auto, but the Sanchez company refused to give the driver a new automobile, right?
Yes, Your Honor, but respectfully, I do not believe that matters. In other words, if the Silverado was an insured auto, which it was, then once it crashes and he uses his personal auto with permission, which he said he did, and there's no dispute about that, and he was using it just the same way he was using the Silverado. So I don't think it matters. I think it's a red herring whether they gave him a new auto or not. He was using a temporary substitute auto. Nor does it matter.
He had permission then to use it in the business.
Yes, permission from his employer and permission from Hancock.
Okay.
So Mr. Cupido Hernandez on a Sunday, he's a foreman for Sanchez. He is driving to work on a Sunday to set up anchor bolts. So the purpose of the trip is to go, and he's at the security gate. But this is very important. He is on the premises, on the job, at the construction gate, stopping to perform a job required duty, which is to stop, present his electronic identification card to the card reader at the guard gate so the gate can open. And if you look at this Barnett versus Brittling Cafeteria case, that's a case that's very on point, because there the worker, it was a waitress, and she was going into, let me just find it here now. This was a waitress who slipped on the ice right outside the pharmacy where she was going to go work. And the court said, there's an exception to the general rule. Employment is not limited to the actual time when the worker reaches the scene of his labor and begins it when he ceases, but includes a reasonable time, space, and opportunity before and after while he is at or near his place of employment. One of the tests is whether the workman is still on the premises. This is often a helpful consideration, but it's by no means conclusive. A workman might be on the premises of another than his employer, or in a public place, or to be so close to the scene of his labor within its zones, environments, and hazards to be in effect at the place and under the protection of the act. Indeed, our own court is in line with the foregoing within the purview of such naturally related and incidental acts in the course of employment is the movement of the employee in entering at the appropriate time the employer's premises to discharge his function. Now that's a Barrett versus Brittling Cafeteria case. That's a workers' compensation case. But the case that we cite to the court, we couldn't find an exact white horse case, but we did find this case, Hendricks versus National Life Insurance case, Alabama Supreme Court case, a life insurance case, accidental death benefits that would have been provided as if the death was in the course and scope of employment. The guy lived in Alabama, but he worked in Kentucky, and he was living in a trailer, and he died of carbon monoxide poisoning. And the court said, well, this is an insurance coverage contract case. We don't really have a case, but we'll look to workers' compensation law. So they based that Hendricks case said in an insurance contract deck action dispute over the course and scope of employment, you look to workers' compensation cases. Remember that our contract didn't use the phrase course and scope of employment. It said, while used in your business. And that's even a more liberal test, because it's not, we cite, I think, the Alaska case and the Bartolomucci case that say that you got to look to what the person actually used. So respectfully, we believe that under the controlling Alabama law applicable to insurance contracts, that it must be construed strictly against the insured, that he is in the course and scope of employment and was using it while using his business under this liberal test that anything you're doing when you encounter a zone of danger, when you're at the job site or about to enter it, and you're performing an employer required duty. In addition,
your position is that this is an interpretation of an insurance contract case, and we try and so we have to interpret the phrase any auto while used in your business, and we use some Alabama tort law concepts, scope of employment concepts to interpret that provision.
I would say we use workers' compensation concepts because basically, because it's an insurance contract that has to be liberally construed in favor of the insured, that's kind of like why workers' comp is construed liberally in favor of coverage. To go to tort law respondeat superior, remember, liability here is direct because Cupido Hernandez was insured as a driver driving an insured vehicle. This is not a respondeat superior issue where we're trying to impose vicarious liability. And then the other point I would make, Your Honor, which I think is a good point, even if you look to tort concepts of course and scope, this is an important case where his gas was paid for by his employer and his lodging was paid for by his employer. And that brings us to the fourth case that I think controls, which is Chesser versus Putnam. That case held that if the employer provides gas, and in this case, there's no dispute, the gas was paid for by the employer inside the plant, and lodging, that is an exception to the coming and going commuting rule that would otherwise be applicable to not being in course and scope. If you're just commuting to your job, that necessarily wouldn't be in the course and scope of employment. Might still be using it in your business, but because of that Chesser versus Putnam case, I think there's no doubt that the Cupido Hernandez was in the course and scope of employment. And that's why summary judgment must be reversed in favor of Progressive. But summary judgment should be rendered because there's no dispute he was encountering a job-related risk, performing a job-related duty on the premises of the construction site, using it to go to work on a business-related trip. And for all those reasons, we believe that the judgment should be entered under the any auto policy. The temporary substitute auto policy kind of gets a little more complicated. The Silverado was not an insured vehicle on the deck page. However, it was definitely used in the business. He was certainly using it in the business to transport employees to the job site, to drive it all around. And basically, conceptually, he was driving a Nissan Pathfinder, but that ought to be treated like the Silverado. So since the Silverado was insured under the any auto policy, the Nissan Pathfinder would be a temporary substitute auto under that policy. So I think that the trial court really just did not focus at all on Alabama contract law or Alabama law, and really viewed and accepted Mr. Feeney's argument that we shouldn't look to the workers' comp law of Alabama, that we shouldn't look to the contract law of Alabama, that we should look to the more stringent test of respondeat superior. And I think that was error and merits reversing and rendering.
All right. Is anything further, Mr. Smith?
No, sir.
All right. Thank you, sir. We'll hear from you on rebuttal, Mr. Finney.
Thank you, Your Honor. May it please the court, I represent the plaintiff in this declaratory judgment action. Of course, it was filed to secure the judicial declaration that my client does not have a contractual obligation to respond to the liability allegations for the injury to Mr. Kim. I'd like to divide my argument into two parts. First, a brief discussion of why the trial court was correct, and then secondly, a response to the shotgun blast of arguments thrown out by the appellant now. Initially, recall that this is Mr. Caputo worked for Sanchez Construction. He was driving his wife's Nissan to the construction site at Hancock Tire Factory. Upon arriving at the security gate, he did not put his transmission all the way into park. The vehicle rolled forward and hurt Mr. Kim's leg. My client is the automobile insurance liability carrier for Sanchez Construction. The allegation of counsel for Mr. Kim is that the conduct of Mr. Caputo in driving his wife's car and arriving at the factory brings him under the Sanchez insurance policy. And may it please the court, the trial judge was correct in rejecting that argument and entering summary judgment for the plaintiff. There was no genuine issue of material fact, and the conclusion was appropriate. Now, these were cross motions for summary judgment, and they were decided in a written opinion by Judge Hicks and then reconsidered upon motion of the appellant. And again, Judge Hicks wrote another opinion, and there he properly focused on the fact that Mr. Caputo was a concrete finishing supervisor traveling toward the general entrance gate and was not doing his job of being a concrete foreperson at the time of this accident. And the judge specifically found that this did not benefit the employer, this conduct, which is consistent with both Tennessee and Alabama law, that a commute to work as a matter of law is not considered a benefit to the employer. Now, we looked to get to the summary judgment, we had undisputed facts to deal with. Undisputed facts included the fact that the car he was driving was not listed in the policy. The car was actually owned by his wife, that Mr. Caputo testified that he was going to work at the time of the accident, in his own words. He testified that he was a concrete foreman, and in his job as a concrete foreman, he's paid by the hour. He works with tools, he sets forms, he pours concrete, he finishes concrete, he sets anchors. He's a working man that works with his tools. Remember too, that he was not clocked in at the time of this accident. There is nothing about this use of the vehicle that places it within the coverage phrase of, quote, while used in your business. Now, there is nothing unusual about the commercial auto policy at issue here. This is a very standard commercial auto policy. It's written for business entities. It obviously covers the vehicles that are specifically listed within the policy. And it also covers temporary substitute vehicles, which is also a defined situation in the policy. The temporary substitute vehicle must replace an insured auto. Example, a very simple example would be if the insured car breaks down, the employee drops it off at the repair shop, rents a car for the week, has an accident. That's a temporary substitute for an insured vehicle. There's nothing complicated about that, and that is not the circumstance that we have here. The policy at issue also carries a very common endorsement.
Before you get to the next point, Mr. Feeney.
Yes, sir.
Why doesn't the employer's decision to say just use your car or your wife's car instead of us replacing the company car, why doesn't that constitute a temporary replacement?
It's contrary to the facts of the case. And even though Mr. Smith argued that they granted permission, that's just not in the facts, Your Honor. The permission that counsel cites is permission, Mr. Caputo's wife giving him permission to drive the car. And the employer's testimony was, hey, people got to get to work. They can drive whatever they want to get to work. There was no affirmative step of, oh, you've wrecked the Silverado, now you drive the Nissan, and that will be considered your temporary substitute.
But was a decision was made to provide the Silverado as a company car for transportation. Was a decision made that we're no longer going to provide a company vehicle?
Yes, sir. And that's in the testimony. The accident with the Silverado was months before. This is not there's no temporal relationship between the loss of the Silverado and the replacement by the Nissan. The Silverado was wrecked. The company said, we're not giving this guy any more cars. Months later, he was commuting to work in his wife's car, and they're trying to link this back to an uninsured Silverado temporary replacement, and the facts just don't support, the testimony does not support appellant's argument on that point.
All right, thank you, Mr. Feeney.
Mr. Feeney, I have a question. What do you say he was doing when he arrived at the Hancock facility?
I say he was commuting to work, just like he agreed. He arrived at the gate.
You said he wasn't doing his job when he was there.
Right. His job is as a concrete foreperson. Those are the setting the forms, building the concrete structures that will house the factory.
Did he have other employees with him when he arrived?
He did not, by his own testimony.
All right. Thank you.
Counsel for plaintiff suggests that he did in the brief, but it's not borne out by the facts.
All right, thank you.
You're welcome. I was about to talk about the any auto endorsement, which is a very common endorsement that businesses have. And it's not, as plaintiff would suggest, an invitation for any automobile in the state to suddenly be covered under your policy. It's an endorsement that if you look them up, you'll see that it's also commonly called a drive other auto endorsement. And it's for the simple vicarious liability protection that an employer needs if, for example, the mail clerk grabs the afternoon mail, jumps in their own car, drives to the post office, and has an accident while on the business of the employer. The mail clerk's car is not an insured vehicle listed in the policy, but it is in the drive other auto or any auto coverage because it was being used in the business of the insured employer. And as I say, it's a very common endorsement, nothing unusual about it. And it makes sense that an employer would want coverage for potential vicarious liability if somebody is on his business driving their own car. Here, the fact was, and the trial court properly found, that Mr. Caputo was not on company business at the time of the accident. Now, the counsel for appellant wants to suggest that we've got some difficult insurance analysis that requires strained understanding of the verbiage of the policy. What we actually have is a very easily understood policy that should be applied with its plain meaning, as courts, of course, this court has repeatedly said, just read the plain meaning. There is no ambiguity in this policy, and there's no reason to believe that it means anything other than what it says.
Mr. Feeney, which state's law should we apply, and should we apply workers' compensation principles?
We should apply, I believe it's an Alabama law question. And I put that when I initially filed the complaint for declaratory judgment, the first document filed, I put in allegations this policy was formed in Alabama. I mean, we've taken that position all along. This is an Alabama policy. And workers' compensation analysis has been rejected by Alabama and Tennessee courts because workers' compensation is a no-fault system designed to find an employer-employee relationship wherever possible. This is a respondeat superior analysis, and that's the analysis that should apply. And again, Tennessee and Alabama law are consistent on the respondeat superior analysis.
And we use the respondeat superior analysis because that's what you use under any auto while used in your business provision. You use that to analyze.
Yes, sir.
Okay.
It would make the policy consistent that an employee goes out and creates vicarious liability because he's using the car on the business of the employer. The employer is going to be vicariously liable. That's when the coverage applies. As I was saying, the Tennessee and Alabama law are consistent on these points. The trial court properly found that there's no benefit to the employer at the time of this accident. That's because Alabama law says the general rule in that driving to and from work or to work is not a benefit to the employer. And Tennessee, under the Cooper versus Ledford funeral home case, same thing. Any commute to work would be considered for the benefit of the employer if that was the law, and it's just not the law.
What about under the unusual circumstances of this case where the employer has the employees in a different state? The employer's providing the lodging and the gasoline for the employees. Why doesn't that extend the benefit of the employer to the commute
Well,
from the lodging to the workplace?
for a couple of reasons. Number one, the traveling employee arguments come out of workers' compensation, not out of vicarious liability analysis. Number two, counsel suggests that it is undisputed that the employer provided gasoline for this car. Quite frankly, it is denied and very disputed that they provided gasoline. The only statement about gasoline comes from Mr. Caputo, who says he was able to fill up his wife's car at the Hankook factory. The employer testified, no, we do not provide gasoline when we provide a place to stay. So at best, there's a question of fact about the providing of gasoline. But to focus on your question, Judge Bennett, the providing of gasoline under Alabama law is the beginning of an exception to the rule. But there are two elements of that providing of gasoline exception. And I've cited them at page 23 and 24 of my brief. If you provide gasoline to the employee, that's element number one, they have to prove that you provided gasoline. And then number two, the trip has to again be for the benefit of the employer. And that is where appellant's arguments fail again, because the general rule is that commuting to work is not for the benefit of the employer, both Tennessee and Alabama law. So
Even though you're commuting from a place that the employer provides to the employee to live while on this job.
In vicarious liability analysis, correct. Even if you're providing it then. Workers' compensation.
Do you have a case for that?
The reason I have cases from Alabama cited at page 23 and 24 of my brief that state the two elements that I just discussed. And then the cases that suggest a traveling employee somehow is on the job during the entire trip are workers' compensation cases, which are of no benefit because the workers' compensation rules that place employees out of town for a business trip. I have numerous points. I would love to continue. My time has expired. May it please the court.
All right. Thank you, Mr. Feeney. Mr. Smith, your rebuttal.
Yes, Your Honor. I'd like to come back to Judge Bennett's question and I think Judge Clement's question about this gas issue. It's undisputed that gasoline was furnished by the employer. Mr. Lopez, at his deposition, said we didn't reimburse him, but we provided the gas inside the plant. And that's undisputed that the gas was paid for. And those cases are not coming out of workers' comp. Those, in fact, are respondeat superior case. In the Sapanzado case, SAENZPARDO, which we cite in our brief, this was a case where they furnished gas but didn't reimburse for gas, and they said that didn't make any difference, as did the Cheshire case. But then they said, Sapanzado does not allege that Nero was traveling to or from work and points to no supporting fact which establishes or tends to establish that he was driving to or from the job site or to or from an errand that took him away from the job site. So we cite that case as saying Alabama law is very clear that if you provide the gas and the lodging and you are driving to a job site, there is coverage. And the same is true in the Sewell case that we cite. This was a guy who lived in Mississippi. He was a veterinarian. He drove to Dothan, Alabama. He gets into a crash driving away back to Mississippi. And the court said that's in the course and scope of employment because you paid for the gas, you reimbursed it. So it's absolutely clear that that the gas was furnished and that he was not reimbursed for it. And that's all that Lopez said. So then the second point, Judge Bennett, again, we believe that this insurance contract dispute is governed by the workers' compensation law, which gets into the stepping on the ice outside the property and any zone of danger, because in that Hendricks case, the life insurance carbon monoxide case, when we had to decide whether there was accidental death benefits for being in the course and scope of employment, the court said, well, we're going to look at the workers' compensation law. So, this idea, and I think Mr. Feeney is absolutely wrong, the any auto coverage is not limited to vicarious liability. It provides that is an insured auto while used in the business. It doesn't say only in cases of vicarious liability. And in this case, we're suing Mr. Cupido as a defendant, and he's covered under this policy, under the any auto policy. And there's no vicarious liability restriction in the policy. So respectfully, we believe if you apply Alabama contract and workers' compensation principles, this auto is used in the business. Thank you.
Thank you, Mr. Smith and Mr. Feeney, for your arguments. They are very helpful, and we will take this matter under advisement. Mr. Hibner.
This honorable court is now in recess until 10 a.m.